Welcome to Washington Focus. My name is Spencer Pauly, Western Washington reporter for the Center Square. And with me today is Eastern Washington reporter Tim Clauser. Tim, let's talk about a story of yours from earlier this week. You covered the Washington House advancing a bill that allows judges to drop charges for low-level offenders. Let's go ahead and start getting into this. Can you just tell me what this bill entails?
Yeah, so it sounds pretty basic when you put it like that. House Bill 1113 would essentially authorize a court to dismiss low-level charges upon substantial compliance with court-ordered conditions. So basically, upon the motion of either party, whether it be from the prosecutor or the defense, they can motion to dismiss these charges. Now, typically, diversions only take place when recommended by the prosecutor. They have a lot of oversight over that, but this expands that, creating a structured pathway, whether or not the prosecutor agrees. Now, everything in this bill really continges on that substantial compliance standard, saying that, look, if you substantially comply with court-ordered conditions, whether it be attending rehab or some sort of treatment, then you qualify to have these these charges dismissed. Sorry.
Okay, I hear you. Well, why have this bill? Is there just like a ton of backlog of crimes that we're seeing across the state? Is this what this bill is trying to work on? Is get rid of a backlog of cases?
Well, Democrats essentially said they were trying to break the cycle of incarceration with these lower level offenses that with some offenders happen quite frequently. But they also brought up the fact that, Washington state is grappling with both a shortage of public defenders and prosecutors. And this makes it difficult to get a lot of these cases through. Now, I know in Yakima, Seattle, and other areas, they're especially being hit hard with this. The prime sponsor of the bill said it in her district of Seattle that judges are dismissing upwards of 45% of non-traffic misdemeanors. No, those are people that are just getting their charges dismissed and they're walking free just because the courts can't handle those cases. Now, they're arguing that this bill would improve the process by, saying we could still dismiss those charges and sort of free up this barrier, but at the same time require these people to do something that holds them somewhat accountable.
Through diversion or rehabilitation programs is what you're saying, right?
Yeah, so the bill is centered around the diversion opportunities. Now, it talks a lot about dismissals, but really it's the opportunity to get this dismissal upon compliance with these diversion programs. I have some details about the bill up in front of me. Now, the diversion programs could include a recovery navigator program, another called an arrest and jail alternative program, law enforcement assisted diversion program, true blood high utilizer program, or other locally established diversion programs. So it's intended to free up the courts, but there is concerns from Republicans across the aisle that, this essentially removes accountability for a lot of these offenders that are habitually committing these offenses.
Yeah, and like you said, it could free up the courts, but what I'm thinking is it might also create more work for these programs. They're going to be at capacity, over capacity, and not be able to give the same amount of services and treatment that they for each individual that goes through their programs. That's something that I'm kind of thinking about.
Yeah. I think it's safe to say that, the fact alone that they would have to substantially comply requires the court to monitor their compliance. They need to be looking at, like, is this person doing what we told them to do? To what degree? And to what degree of them not doing it qualifies as them not complying? Now, through this process, a judge would issue a continuance in a case for 6 to 12 months. And during that time, the offender would be required to participate in these diversion programs. And also another required aspect of this bill is that they would have to pay full restitution. But at the same time, the bill says that a person being indignant cannot be a barrier to a judge granting a dismissal. So basically it's saying that, hey, look, you have to pay restitution for these crimes. You have to pay these fines. But if you don't have the money for it, no worries. You can still get the dismissal anyways.
Now, before we go into this, when we talk about low-level crimes, what exactly does that entail? I don't think we've touched on that yet. What are these like theft? What else, what are these crimes? Drug possession?
So they're looking for low-level offenses, nonviolent ones that it's hard to say would not have a clear victim. So they're saying instances of low-level theft, drug possession, and others like that, not cases of stalking, sexually motivated crimes, DV, even DUI, reckless driving. Those crimes are not they don't qualify for dismissal under this bill. So it's trying to focus on crimes where, say, maybe you have a homeless person who keeps getting trespassed from a property over and over again. Rather than putting them in jail or having them pay all these absorbent fines, they'll require them to maybe attend a drug rehab if that's tied to their condition. But again, it continges on that substantial compliance standard. And the court system varies depending on where you are. I mean, you're located in Seattle and I cover Spokane. Those are very different jurisdictions and have very different viewpoints on life. So the way a King County judge might interpret substantial compliance might be a lot looser than, say, a judge out of Spokane County. Right. Now, there was attempts from Republicans to pass amendments that would require total compliance and not just substantial compliance. So they would have to follow through with everything the court said. But this was turned down to the dismay of Republicans, ultimately keeping that substantial compliance standard, which they said is already in place. And that's true. But like I said earlier, it could be interpreted very differently depending on where you are.
Yeah, I see this bill as not favorable by Republicans at all in the Washington House. I think every single one of them voted against this House bill. I saw one representative, Jenny Graham, based in Spokane there. She's always been a staunch supporter of crime victims. As many know, her sister was one of the victims of Gary Ridgway, the Green River Killer. Now, when I was watching her testimony during the committee meeting, she said that she's supportive of rehabilitation, right?
Yeah, so she did say that she's supportive of rehabilitation and somewhat of a process to get these dismissals. But she said, look, hey, if we're going to allow people to get these dismissals, they need to comply with what we're saying. We can't give them the option of giving a halfway effort. They need to comply completely. And she was speaking to that amendment I mentioned earlier, requiring that total compliance rather than substantial compliance. And still, despite her and other Republican attempts, it didn't pass through. And now at this point, the bill as it is has been handed off to the Senate. So it did pass through a few committees between the start of the session in January and now. But earlier this week, it was approved by the House as a whole. So it is out of the House of origin, now sent to the Senate, and pending their approval, it could become law later this year.
I see. I'm wondering, some of these offenders, these drug possession, cases, whatnot. When we talk about like total compliance of, or even substantial compliance of any drug diversion programs they might be going through if this bill is passed, they might have to turn a whole 180 on their life trajectory. If these are repeat offenders constantly going through the system, what's going to say, are they going to now change up their ways and say, I'm going to get my life back together? And if that's what these programs do, that's great. But that's one thing I just keep thinking about is, we see it all the time, Tim, out in Washington, especially here in Seattle. I see some of the people out there who are smoking meth on the streets, doing other hard drugs. I'm just wondering if this is what will help, like, these people actually change their ways, or if it's just another way of saying, we're going to make sure we just decrease the case backlog that we're seeing across the state. Now, I'm thinking I would like to see the data about this, but how many of these, this case backlog is drug possession? Because it seems like that's what this bill here is targeting, right? More so,
yeah,
not.
Yeah, it does seem like that. I mean, and there still is opportunities for accountability if they do not substantially comply. I want to make that clear.
Yeah.
If a court finds that a defendant did not substantially comply, and again, that's up to the interpretation of the judge, they have to hold another hearing looking at, look, not only did they not substantially comply, but did they make a willing decision on their own part to not substantially comply? In that case, they would deny the dismissal and they would continue to serve their fine or whatever other punishment that they're facing. But in the event of any dismissal due to one successful Republican amendment that was passed, the court has to make a written statement on why it made the decision and how it got there. It also has to provide, if they're dismissing the case, an opportunity for a victims panel to speak to the defendant before their dismissal. So there are other mechanisms for accountability in there, but I think a lot of this is going to be centered around drug possession cases, things dealing with homelessness in King County, Spokane County, in other areas grappling with that. These relatively low-level offenses that are just piling up in these bigger metros.
Okay, and you said this is going to be sent to the Senate. Is there any set dates where we're going to see this bill discussed over there?
I could be wrong, but I don't believe it has been scheduled for a committee hearing yet. We're just on the cusp of the House of Origin cutoff right now. So they're trying to get a lot of these last minute bills through from both the House and the Senate. So probably into next week and after that, we'll start seeing the Senate pick up a lot of these House bills and the House pick up a lot of these Senate bills that have passed since January.
Well, Tim, I know you'll be covering this and keeping our readers and listeners informed on what goes on here. That will be about it, Tim. Thanks for hanging out with me here talking about this story. This is Spencer Pauly here at the Washington Focus. See you next week.